Good morning, everyone. A very warm welcome. Welcome back to this awesome series. Uh, we have been doing various topics of polity till now, and we have done some amazing practice mock questions as well, right? So here we are with State Government Judiciary, correct? We'll be seeing what are the organs, what are the institutions in the State Government Judiciary, and then we'll be practicing some questions as well. Okay, so stay tuned, stay connected. Let us go through the state government judiciary. It is a very important topic from examination point of view. Often questions are asked because Supreme Court and High Court, yes, questions are there, but still, this is still less touched area, so you can expect questions from this. Okay, let us start. So we have seen the apex court in India is Supreme Court, right? The central judiciary is Supreme Court and High Court. And 70% courts in India are subordinate courts. 70% courts. 18,000 plus active courts across India. This is the data of Department of Justice in 2023. 18,000 plus. Correct? Primary backbone of justice, delivering, handling civil and criminal revenue and family disputes at the district and local levels. Lowest level, we have seen anchored by Nyaya Panchayats and village courts. Correct? So you can say they are the backbone of the judiciary. Am I right? 18,000 plus courts. So you can imagine how many cases would be pending right now. There is a lot of pendency in the cases. So that is why subordinate courts or state judiciary becomes very important for us. Correct? So let us dive deeper into it. Part 6 of the Constitution talks about the governor and the high court. Okay, so they're talking about the appointments under article 233 and 234. Okay, uh, under high court supervision, governor will appoint. Okay, in consultation with the high court and state public service commission, the governor will appoint. Okay, supervision will be high courts. So subordinate judiciary appointment will be by governor via consultation with high court. Supervision will be via High Court under Article 235. Correct? So please remember this appointment by governor and supervision by High Court. Now, this governor, it is in consultation with High Court and PSC. Okay? Article 236 says that district judge, it defines district judge, which includes any city civil sessions and assistant judges. City judge, civil judge, sessions judge, correct? Sessions judge is nothing but a district judge when he performs the function of uh, into the criminal cases, when he looks for the hears for the criminal cases, right? Article 237, 233A, it gives governors power to apply rules to magistrates and retrospective validation. Okay, Article 236 is important for us. Make sure you are getting to know 235 and 236. Very important. Okay, so please remember appointment by governor with consultation of High Court or PSC and supervision is by Supreme High Court. Okay, continue. Now, there are three pillars of jurisdiction in subordinate judiciary, correct? Civil courts, criminal courts, and revenue courts. Okay, now which are these courts? Let us have a look. Civil courts means they will listen to the nature of the dispute will be property, succession, contracts, landlord, tenants, divorce. Correct? These are the civil courts. What is the guiding framework? Civil Procedure Code. Correct? Now, many of the codes like IPC, CRPC, they have been renamed. So, put in the comments what is the new name of Civil Procedure Code if so. Okay? If it has got a new name, let me know which name is that. Okay? Dispute settlement injunctions, rights enforcement, no penal punishment. Now, this is the thing. Key outcome is they cannot give penal punishments for civil matters. Important. Okay. And this is also important. This is what? This is civil courts. Now coming to criminal courts. This will be like violation of laws, criminal acts like theft, assault, murder, etc. They are again governed by the Criminal Procedure Code and Indian Penal Code. This, ka, this is the new Bharatiya Nyaya Sanhita, correct? Bharatiya Nyaya Sanhita. What punishments can be given? Fines, imprisonment, and capital punishment. Capital punishment can be given by subordinate courts with consultation or guidance of High Court. Okay. Then comes revenue courts, land revenue, tenancy, agricultural property. So this is the guiding framework here is state specific land revenue codes. So they have every state has their own specific codes, and land record corrections, revenue assessment, and agricultural dispute resolution is the ultimate aim, objective, or say you can say key outcome of the code. Correct? Civil court is known as normal when it is functioning as a civil court, but criminal courts at the district level is known as sessions court. Sessions court. Okay. So going ahead, hierarchical. So I told you about district court, sessions court. Now let us see how the hierarchy works here. Okay, in a civil court, it starts from Nyaya Panchayat at the grassroots level. Gram Kachehri, we say Gram Kachehri. Okay, Kachehri. Petty civil cases, 10,000 rupees, 5,000 rupees, petty amounts, 500 rupees, like that. Above that comes lower civil courts, or you can say municipal courts. Above that comes lower civil courts or municipal courts. Then comes highest civil authority in the district, that is the district judge. District judge. So you can see district judge itself is at the third level. So the first level is Nyaya Panchayat, okay, or Gram Nyayalay, and then comes lower civil courts, then comes district judge, which is the highest civil authority. Okay, then we have the revenue side. We have first the assistant tehsildar and tehsildars, correct? Above that, we have courts of collectors and commissioners, collectors, district collectors, like that. And then we have board of revenue, highest revenue court in the district, which hears the final appeals. Okay, so this is how the hierarchy works in the subordinate judiciary from district to grassroots level. Okay, I hope this is pretty clear for you. Nyaya Panchayat, lower civil court and district judge, tehsildars, assistant tehsildars, court of collectors, and board of revenue. Okay, let us go ahead. Then we have the more important one, which is the criminal hierarchy, the criminal court hierarchy. Correct? Confirmation rule is there. I told you that any death sentence passed by a sessions judge is not final. This is not final. It cannot be carried out unless explicitly confirmed by the High Court. So please remember, it might come in your exam that sessions court can give a capital punishment independently. No, they have to get it confirmed by the High Court. Okay. In criminal hierarchy, we have the judicial magistrate, second class. Okay, so the grassroots level, we have judicial magistrate, second class. Up to 1 year of imprisonment they can give or fine. Okay, this is the magnitude of the punishment which they can give. Okay, then judicial magistrate, first class. Up to 5 years of imprisonment they can give. Correct? Then comes chief judicial magistrate or assistant sessions judge. They can give imprisonment up to 10 years and controls other magistrates. Okay, and then comes the sessions judge. They can give any sentence authorized by law, including capital punishment. Okay, so this is how the hierarchy of criminal subordinate courts work. Judicial magistrate, second class, judicial magistrate, first class, chief judicial magistrate, sessions judge. Okay, please remember, again I'm telling this point, sessions judge cannot give a death sentence without confirmation from the High Court. Okay, let us go ahead. So here is a quick matrix here. District Judge, Article 233, this has to be memorized, and other judicial officers 234. So 233 is District Judge. So appointment has to be done by the governor in consultation with the High Court. We saw this. Minimum 7 years of practice is required as an advocate or a pleader. This is the eligibility criteria for district judges. What? 7 years practice as an advocate or a pleader. They cannot be a current employee of in any union or state government department. They should not be a current employee. And they should have direct recommendation by the High Court of the respective state. So the High Court needs to give a recommendation that person so and so becomes the judge. Okay, so please remember this. The governor will appoint the district judge. Okay, minimum 7 years of practice is needed as an advocate. They cannot be a current employee anywhere else, and direct recommendation by the High Court. Okay, for other judicial officers, again, they will be appointed by the governor, must consult both the state public service and the High Court. So the governor must consult the SPSC and State Public Service Commission and the High Court. Not explicitly restricted by same baseline prior service rule. Okay, it is not explicitly restricted. Okay, what appointment eligibility? Okay, appointment eligibility. Okay, recruitment conducted through the rigorous state judicial service examinations. So the recruitment is conducted via the state judicial service examinations. Okay, this is the eligibility. Okay, so this is the appointment matrix, qualifications, eligibility, and what is the recommendation required for them. Correct? Let us go ahead. Yes. So, the caseload crush we can see here. Case load crush means the total pending cases. So, over 4 crore pending cases trapped in subordinate system. This is the data. 4 crore cases. Correct? Human capital deficit. We have almost 20 to 25% of all sanctioned judicial posts remaining entirely vacant. So can you imagine 1/4 of the judiciary is not working only right now? Correct? Infrastructural bottlenecks are there, severe lack of digital facilities, modern courtrooms, administrative staff. These bottlenecks are still there. What is the consequences because of this? Because of these three consequences, what are the issues? Prolonged, costly litigation eroding public trust and restricting rural access in fundamental justice. Access to fundamental justice. Obviously, pendency is there, correct? Then the cases get delayed, justice get delayed, correct? So please remember, almost 4 crore cases are ending in the Indian judiciary. Okay. How to bridge the gap? We need technological evolution, correct? We need to expand the e-courts. Mission mode needs to be required for project for faster case management. We should promote lok adalats and mediation to divert non-critical burdens. Also, speedy recruitment drives and capacity building for judicial officers is required. Correct? This is under human resource injection. This is under alternative dispute resolution. Correct? Systemic upgrades. Mm. Systematic upgrades. So morning, evening, holiday courts and upgrading physical and court complexes. So all these things are required for bridging the gap. Okay, for bridging the gap of judiciary, because to clear up 4 lakh cases, it is a bit of a task, right? So here we saw a word, lok adalat. What is this? Lok adalat is alternate dispute redressal. Okay, alternate dispute redressal. Now how does that work? So the lok adalat has the backing from the uh, legal, legal Services Authorities Act. Legal Services Authorities Act 1987. They are like courts outside of courts to settle disputes before itself. They should not go to the higher judiciary. It is to clear the pendency of the cases. It is an alternate dispute resolution mechanism. Correct? It is at a pre-litigation only. It is like you can say in some cases it is like a settlement. Okay, so basically it is very much cost free. There are no much costs involved in it. Yeah. But one more thing is there is no appeal. So if they have made a judgment, you will have no appeal for that to any high court or supreme court. Okay, mutual consent is required to accept the mediation result. Okay, so this is how the Lok Adalats work. So, seeing it, we have the state high court, we have the supervision under 235, we have the civil courts, correct? Property contracts, then we have criminal courts, sessions court, correct? This is called as sessions court. Offenses and penalties, and then we have revenue courts, land and agriculture. So, Article 233 to 237 uh, forms the constitutional bedrock of the Indian judiciary, right? Citizens and grassroots, we have Nyaya Panchayat and Gram Kachari at the grassroots level, at the bottom level. Subordinate courts are not merely low tiers. They are the primary interface for justice for 1.4 billion citizens, translating constitutional guarantees. So we can say that they are the lowermost compared to Supreme Court. But actually, if you see, they are the first point of contact from the public to the judicial system of India. That is why they become super important. From examination point of view, what is important for us? From examination point of view, let us have a quick recap. From examination point of view, these articles are important, 235, 236, correct? This is required. Uh, a district judge, correct? This flow, you should know this flow, hierarchy of flow is needed, correct? You should know this flow of who is known as sessions judge, who is chief magistrate judge, what is the punishments they can give up to 1 year, up to 5 year, up to 10 years, correct? This is very, very, very important. This slide is very important. How they are appointed, what is the eligibility criteria, what is the minimum qualification, and what are the recommendations, correct? Then, what else is required? This is required. Article 233 to 237, you should remember, which is involving the subordinate judiciary. Okay. So here we have seen the state government judiciary. We have seen all the nuances, eligibility criteria, correct? Appointments, how the structure works. Now, let us have some practice questions, correct? Don't look at the answers. Left side is the question. Okay. Don't go on the numbers, just skip it. We'll start with the questions. Practice is very much needed. The more you sweat in peace, the less you bleed in war, right? So come, let us practice some questions. Which among the following is not a part of subordinate judiciary? Which of the following is not a part of subordinate judiciary? Is it a district court, sessions court, supreme court, or magistrate court? Very easy. If you have seen this video, it's super easy. Obviously, Supreme Court, right? So Supreme Court is the apex court of India and not part of the subordinate judiciary. This is the subordinate judiciary. District court, sessions court, and magistrate court. Okay. Supreme Court is the appellate court, apex. Okay. Next, the subordinate judiciary in a district is headed by the subordinate judiciary in a district is headed by whom? Chief Justice, District Judge, Governor, or Advocate General. So this you can eliminate aram se. Advocate General is again at the state level. District Judge or Chief Justice? It is District Judge. their highest judicial authority at the district level. Okay, they will head three people: first, civil judges, chief judicial magistrate, and other subordinate courts. So, district judge is the highest authority in the district. Okay, next, the High Court, the Court of District Judge, deals mainly with the Court of District Judge deals mainly with constitutional disputes, civil and criminal appeals, election disputes only, or international law. Think and tell. Obviously, international law they will not. Correct? Election disputes only? No, don't have the authority to deal with election disputes. So what they will deal with? They will deal with civil and criminal. So district court hears important civil and criminal matters and appeals from lower courts. Okay? Civil matter appeals and criminal matter appeals. Okay? Yes. Which among the following is a civil court at the district level? A civil court, not criminal court. It is a civil court. Sessions court, district court, court martial, or Gram Sabha? What do you think? So it will be district court. Court martial is for army. Gram Sabha is at the village level. Correct? Sessions court is criminal court. This is the criminal part. Correct? In terms of civil, we have district court. Correct? District courts mainly handle civil matters at the district level. Okay. Now, what are these things? They are property disputes. Correct? We have here property disputes. Then we have contract breaches. Correct? Contract breach. I'm writing here so that if this part is not visible because of my screen, then and family laws. Family laws. Correct? Contract breaches, property disputes, and family laws. Civil court will hear that. Okay. Next, the sessions court mainly deals with the sessions court mainly deals with just now we saw taxation, no, that is revenue court. Constitutional matters, no. Revenue cases, no. So criminal cases. Sessions court will always hear serious criminal cases such as murder, robbery, etc. Correct? Minor offenses, petty offenses, then we have severity scale. So in the severity, most severe cases, major offenses will be listened by sessions court. Okay, like murder, robbery, rape, etc. Okay, which of the following courts is the lowest court in criminal cases? This is a good question. It can be asked. You should know in the hierarchy, which is the lowest court in criminal cases. Obviously, out of option. Now tell me, sessions court or magistrate court? So it is magistrate court, which is the lowest court. Judicial magistrate courts are the lowest criminal courts in the subordinate judiciary, state government judiciary. Correct? Then we have sessions court, then we have high court, then we have supreme court. Okay? So magistrate court is the lowest. We have seen here, I'll just repeat this. See, judicial magistrate. The judge is called judicial magistrate second class. Then he gets promoted and he becomes judicial magistrate first class. Okay? Okay. Next, which article of the Indian Constitution deals with the appointment of district judges? Remember, I told you these articles are very important. Correct? So, which article deals with the appointment of district judges? Article 233 deals with that. It deals with the appointment of district judges by the governor in consultation with the High Court. Exam may it will be asking, uh, options will be given: governor, chief justice of High Court, like these president. These will be the options given, and you will get confused between these two. That higher, either it is subordinate judiciary, so chief justice of High Court should be appointing. No, it is the governor who does it with consultation with High Court. Okay, so please remember Article 233 deals with appointment of district judges. Next, who appoints the district judges in a state? Just now we saw the governor does it. Article 233. Just now we saw. Correct? The governor does it. They are appointed by the governor in consultation with the High Court. Correct? Which authority conducts consultation for appointment of district judges? Which authority conducts consultation? Just now we saw. So the governor consults with High Court. So please remember this. I have given so many questions so that you remember. Correct? Governor plus High Court. They select the district judges. Okay? District judges. Consider the following statements. I have brought some statement problems for you because now the statement problems have started coming. Correct? So they are important. We should have a practice of solving them. District judges are appointed by the governor. Appointment is made in consultation with the High Court. So same two questions I have put in a form of statement. So which is correct? One only, two only, C only, or both only, or neither? So both are correct. They are appointed by the governor and in consultation with the High Court, Article 233. Which article provides control of High Court over subordinate courts? Which article provides control of high courts over subordinate courts? So it is Article 227. Okay, it gives High Court the power of superintendence over all subordinate courts in the state. So see, they have the High Court. The High Court has the umbrella of supervision over district court, sessions court, and magistrate court. Okay, they have the ultimate supervision authority under Article 227. Next, the control over district courts and subordinate courts lies with super easy answer. Just now we discussed High Court. Okay, so control supervision Article 227. We saw one more important article 233 appointment. Correct? So High Court exercises administrative and judicial control over subordinate courts. How administrative? The postings are done by High Court, promotions are done, leaves are approved by High Court. But judicial control, how? Appeals are heard in High Court, revisions and transfers. Okay, so this is important. Again, a statement problem. High Court supervises subordinate courts. Subordinate courts are independent of High Courts. Article 227 deals with High Court supervision. What do you think? Which statement is correct and which is wrong? Let us have a look one by one. High Court supervises. High courts supervise subordinate courts. Yes, just now we saw. Subordinate courts are independent of high courts. No, they are not. Article 220 deals with high court supervision. Yes. So the correct answer is 1 and 3. Subordinate courts function under the supervision of high courts. Just now we have seen that it is not independence. Okay, keep this in mind. Separation of judiciary from executive is mentioned in which article or which part? That the judiciary should be separated from executive. Which part deals with that? Directive Principles of State Policy. Under Article 50, DPSP directs the state to separate the judiciary from executive. So always remember Article 50. How to remember this? We have 50-50, no? 50-50. So either judiciary को separate we have done with executive 50-50. So 50 so you remember. Okay, Article 50 it is under DPSP. Okay, please don't confuse with Article 51. It is for international peace. Okay, and 51A is what? What is Article 51A? Please put it in comments and tell me. Okay, what is Article 51A? So please remember separation of judiciary, Article 50, DPSP. Nyaya panchayats are associated with Nyaya panchayats are associated with military justice, village level justice, international disputes, or constitutional amendments. A very easy question, a very obvious, correct? It is at village level. Nyaya panchayat. Village level justice, they help settle minor disputes in rural areas. They are called grassroots justice, minor localized disputes resolution without formal court friction. So, Nyayadhikaris are there, Gram Nyayadhikari. They go. Nyaya panchayats are also mobile, means they can go from village to village like that. Okay. So, friends, we have discussed the entire subordinate, that is a state judiciary here. We practiced few questions among them. Make sure you are watching this series completely. Every topic of polity, almost all important topics I have explained. I'll be explaining further also. We will be coming up with judiciary as emergency as well. Correct? Stay tuned for further topics. Please practice the questions and stay tuned with Oliveboard for more content and information further. Thank you, everyone.